Hi, everyone, and welcome to this edition of Judgment Day. I'm Lorne Honickman. And, here on Judgment Day, we talk about cases that go to court, cases that are about to go into court. And we're also going to talk about laws that could probably end up going to court to be adjudicated one day. And unless you've been living under a rock for the last couple of weeks, you have heard a lot about something called Bill C-10 that is coming out from the federal government. And of course, that is the Broadcasting Act reform bill. When we talk about reform, that's going to be the bill that's going to change the Broadcasting Act, give different powers to the CRTC. And of course, one of the most controversial parts of this, and that's what I meant about unless you've been living under a rock, is this bill and what's proposed in this bill going to affect user-generated content? That could be content that you generate. You decide you want to post something on TikTok or Instagram, or maybe it's just a YouTube video that you're putting together. Do you become what's called a programmer? And if so, are you then subject to regulation by the CRTC? That, for many people, would immediately infringe freedom of speech, or as we properly call it up here, freedom of expression. Now, one of the people who has been speaking a lot about it, and he certainly has the credibility to talk about it, given his background, is lawyer Michael Geist. Michael Geist, a law professor at the University of Ottawa. He holds the Canada Research Chair in Internet and E-commerce Law. He's a member of the Center for Law, Technology, and Society. He's been watching this closely. So let me bring Michael into the show. And there you are, my friend. Thank you for joining me.
Oh, it's a pleasure. Thanks so much for having me.
And Michael, I haven't been able to say these words in a long time since my days on CP24 and City TV, when I sat in what would be known as maybe like an anchor type chair. But I'm going to go to you with breaking news, because I know that, and so everybody understands, this bill is now at committee. The committee has been meeting this week. We started the week, Michael, hearing from the Heritage Minister that don't worry, user-generated content is not going to be caught from this. And then there were changes made and all sorts of confusion. Where are we at this moment in time as we speak?
As we speak, actually, we're recording this while the committee is in fact meeting. They've been spending the last couple of hours debating a motion to consider whether or not there will be a Charter of Rights and Freedoms review of the bill, and if there will be, when it will take place, and what the committee will be doing while that review is taking place. So it's a lot of procedural maneuvers, I think, going on between the various parties, which and unquestionably has had the effect both, I think, of escalating public interest and concern with this legislation, and quite obviously slowing down the review process that the government would like to see accelerated.
Okay, so let's talk then about where we're at today, and then we can get into the potential ramifications. The week started with Minister Guilbeault saying something like, "We want to make sure that the content that people upload on social media won't be considered programming under the act. It won't be regulated by the CRTC." So it looked like they were pulling back on something they put in the first place, and that's a whole other story, of course. Why put it in if you're going to pull it back? However, from what I understand, it's still in there, or at least a form of it is in there. Am I right about that?
Yeah, you are. So this legislation, which, when it was first introduced, was supposedly about bringing large streaming services like Netflix and Disney into the Canadian system. And there was a recognition at that time that the government wanted to exclude user-generated content, the millions of Canadians that upload to YouTube or use TikTok and Instagram and all of these other services, and that if you didn't create an express exclusion for them and their content, that it could be considered a program under the law, subject potentially to CRTC regulation. And so that's where we were. And then all of a sudden, a couple of weeks ago, the government introduces an amendment to their own legislation where they remove one of those exceptions. So they kept the exception that would that would exclude users from being treated like broadcasters. So they didn't want a million TikTok users having to show up before the CRTC for potential hearings. But they still maintained the provision, or they removed the exclusion that protected their content. And so the effect was to say that all of that content, all of the videos and audio podcasts like this one would all be treated as a program under the law, potentially subject to CRTC regulation. That, as you say, sparked an outcry. The government suggested, well, we'll fix it. But the fix that they most recently introduced, quite frankly, doesn't fix it and still keeps that kind of content subject to regulation as a program.
Okay, so let's get down to the nuts and bolts. And we'll talk about freedom of expression, freedom of speech in a moment. And the philosophical reasons why this hits us in the gut if anybody says anything about we're going to regulate what you say. Okay, because there are a lot of layers to this, Michael, as you know. But let's make this more understandable if we can. If you are a programmer in this proposed legislation, so if indeed this were to go, and now you as an uploader to YouTube or all the different platforms, as you say, you're now under potential, or you are under the regulation of what this act regulates. What could that potentially mean? Let's talk about this from a practical point of view.
Yeah. So let's just reiterate that they are at this stage not saying that the individual is a programmer, but what they produce is a program. Okay. And so just that we make That's it clear yes. that they're not suggesting that the individual is essentially akin to a broadcaster, at least under the law, but they still want to almost have their cake and eat it too. And they're saying that their content is a program, and so it's subject to regulation. Now, as you will know from your experience, the CRTC has very broad powers with respect to its ability to regulate this space. And as part of Bill C-10, there is an effort to extend its powers to address the online world. So what started with more conventional broadcasters and broadcast distributors like cable companies is now being extended to the internet as a whole. So those powers are broad. Now, the government says we're going to try to limit some of those powers, but there are still some very real powers that the CRTC will have, perhaps most notably the prospect that the CRTC can, in a sense, get into people's individual feeds on their TikTok or their Instagram in the name of trying to prioritize Canadian content, so-called make it more discoverable. Right. I should note there is no country in the world that thinks that government should be in the business of regulating user-generated content in that way. But the moment our government thinks that it can, and that's precisely what it wants to do.
So again, this is an important distinction, as you say, not the programmer, not me or you as an individual, but perhaps this podcast or this webcast, for example. And you're saying, and again, I just want to, because I'm just trying to drill down to the practical potential ramifications, if I could say it that way. So somebody's content could then be examined by the CRTC, and the CRTC could come to that individual who's been posting for a year on Instagram, and the CRTC could say, we've got some concerns about your content. There's not a lot of Canadian content in it.
Yeah, I think it's unlikely that we would see the CRTC get into that level. I think what is much more likely is that the CRTC will go to particular platforms, to the YouTubes and TikToks of the world, and say, we want to ensure that the feeds people see, the various videos they see, whether on YouTube or Instagram or TikTok, and there are, of course, many others, we want to make sure that there is Canadian content in those feeds. And so we want you to tweak your algorithms. We, the regulator, are in a sense going to start getting into the programming of those algorithms. And we want to ensure that Canadian content becomes more discoverable, becomes more readily apparent. Now, I should note that kind of approach, of course, in the conventional broadcast world is pretty common. There's requirements to show a certain amount of Canadian content. And there are a number of countries that have moved to try to create something similar for internet streaming services. So they would like to see, for example, Netflix prioritize Canadian content and make it more discoverable. But I think most countries, indeed, as far as I can tell, all countries have recognized that once you start getting into the speech of millions of Canadians, the idea that somehow you can identify Canadian content in that space and say that you want to now dictate or have the government dictate some of the outcomes of that algorithm, I think is viewed as something that is unworkable. And I think in many ways pretty dangerous, because that really is speech and speech regulation speaks not just to what we say, but the ability for our expression to be heard. And the government is really, in a sense, intervening directly in that.
So the tentacles of the regulation, if I could put it that way, are going to be stretched out to the platforms, not to the individual. Now, the individual, it'll trickle down if I understand what you're saying. But again, to just talk about it from a practical point of view, it could be CRTC coming to, and I'll just use YouTube as an example, stating concern, saying what we've looked at what you're posting up there, what everybody's doing on an individual basis. There's not enough Canadian content on YouTube as we see it right now. So you're going to have to make some changes here. And those changes, if I understand what you're saying, Michael, could then trickle down and have an effect on the individuals who are posting. Am I simplifying it properly?
Yeah, no, I think that's right. I mean, I think that they potentially could look even more granular than even just the platform as a whole in terms of the amount of Canadian content, even more to say that we think at an individual level for the literally millions of Canadians accessing your site or your service, we want to ensure that a certain percentage, in a sense, of what they see, what is recommended to them, the kind of videos that appear, let's say, are Canadian. And so we are going to make it incumbent on you as a condition of operating in this country that you make sure that there's a certain amount of Canadian content that appears directly in their feed. So it's not just even on their platform as a whole, it's how individuals will experience these different kinds of services. And bear in mind that the ability to even identify what counts as Canadian. So that even if you were to say, okay, I think this is a good idea, although I have my doubts, the ability to even identify what's Canadian in this context isn't something that we have unless suddenly the government also is going to require Canadians who use these services to disclose more information about themselves to the platforms. Now, suddenly, they want to start linking where I'm from, my geography, and the like, so that they can begin to meet this new government regulation.
Right. And the regulating the internet. I used to say, Michael, that the internet was like the Wild West. There was no regulation at all, and indeed even to today. Um, let's talk about what's sort of sprouting out from this, and that is something called and I don't know if it has an official title yet, you'll tell me, but it's going to deal with online harms, and I put harms in quotes. Things like child sexual exploitation, terrorism, violent hate speech. Is this another part, an adjunct of this bill that's going to try and regulate that part of the internet as well?
Right. So it's actually part of a broader legislative plan for the government. It's not going to be part of this bill. It is part of another bill. And so if you're someone that's been paying attention to C-10 and saying, wow, I'm pretty unhappy with what I'm seeing the government doing with respect to the internet and internet regulation, candidly, you ain't seen nothing yet. Because what the minister, and it's the same minister Guilbeault, has said is forthcoming in this so-called online harms legislation is everything from mandated website blocking to mandated takedowns, oftentimes within 24 hours, to even creating a new social media regulator who will sit alongside the CRTC.
Well, you know what, Michael? There could be a lot of my clients, present and past, who would be saying who they themselves were victims, and I put that and I underline it, victims of online defamation, which irreparably harmed their reputations, where we either had to go through trying to get orders from courts. And if I had ever said to them at one point, don't worry, we've got the government, we've got a regulator that we can now write to, and they can get that down in 24 hours. They would have been pretty happy about that. You know that as well, that there's a lot of harm taking place on the internet as that goes beyond just hate speech or terrorism or child exploitation. What do you think about that? The fact that it may not be such a bad thing to have access to that potential remedy.
Yeah, no, I think that's a great point. And I think people should be clear. No one, I don't believe, is saying that there should be no regulation online. And first off, it's quite clear that online applies offline as well. So there is a need to ensure that those rules continue to apply. What we're talking about in this context, though, are issues like effective due process, because if we are going to say that there's going to be takedowns, we need to ensure both that we're dealing with clearly unlawful speech and that there is an appropriate set of due process. And what I worry about when I hear the minister talk about, let's take this thing down in 24 hours, is it's pretty hard to ensure that you've got effective due process without it. And if you don't have that, then I fear that very often the targets for taking down speech will be the very types of people we are seeking to protect. So, for example, those different people in different minority groups and the like. I think that oftentimes they're worried of being targets of hateful speech and I completely understand that concern. It is a reality. The
Right.
problem is those same purveyors are going to target their speech as well. And so you need to ensure that you get the balance right. It's not to say that you don't want to ensure the law applies. You absolutely do. You want to ensure that we're dealing with illegal content, not just stuff that may be harmful or hurtful, which are things the minister has said. And you want to ensure that you are taking down the right stuff, not just taking down stuff as quickly as possible. And I worry that the minister has kind of lost sight of sort of those broader objectives as part of his legislative proposal.
Right, but you can see, Michael, the gray line, right? We talk as lawyers, black, white, and gray. So there's speech up on the internet. Somebody posts on social media something about Michael Geist. It's not hate. It's not any type of threat. It wouldn't fall into what we'd call a prima facie case of 100% anybody looks at it. But for Michael Geist, it's really harmful because it's really impugning his reputation. Michael Geist has no one to turn to except perhaps another lawyer like me to try and do anything and everything he can to get it down. And by the time I can, it may be too late. Where do we get that due process in that you're talking about? Can we actually see an entity, if it's a government or not, that can deal with that type? Because I think those types potential regulatory bodies may be very helpful in the world of online defamation that maybe doesn't reach those hate categories.
Listen, there's no doubt we need to ensure that we hold companies accountable, that they live by the principles and the policies that they establish. I think there's a feeling, I think quite rightly, that they are inconsistent at best with applying some of those policies. We need to make sure that these companies are willing to abide by Canadian court orders or the kind of authorization that you would look to. There's been at times, I think, inconsistency there as well.
Right.
So this is not or cannot be a free for all. We need to ensure that the companies do better, and laws and regulations, I think, are part of that. But I also think that we need to tread carefully, because I do worry that some of these proposals, while perhaps well-meaning, will have the effect of actually harming some of the very people that we're seeking to protect.
Yeah, no, I totally agree. Listen, before we wrap this up, let's go back to Bill C-10 for a moment. You could see how much there is to talk about with this. There are parts of Bill C-10 I don't think people would disagree with. Maybe they will, sort of taxing the Netflixes of the world, if I understand it, and putting them in the same category as other media. But getting back to the user-generated content aspect of it, because we started our conversation, Michael, you were telling me that they were talking about a charter motion or dealing with the charter. One would assume, well, maybe I shouldn't assume when it comes to government ever, but I'm going to assume that before they put a bill together, they're going to look at it and see if it's going to meet charter scrutiny. Are they not? You don't want to put a bill out where the next day you've got a charter application. Right?
Yeah, no, of course. Yeah, no, of course you are. Of course, that would be the expectation. And in fact, it was the Liberal government that went a step further. They said that as part of every piece of legislation, they actually want a charter review so that the public can understand that charter analysis. What has taken place, though, the change is to come back to where we started, is the removal of one of the safeguards for user-generated content. And so the argument from MPs, and this has come from a number of opposition parties, is that, well, listen, if you are going to remove some of the protections or safeguards for user-generated content, that sure sounds like you now have changed the charter analysis. And so what they've said is, listen, before we keep going through a clause by clause review, before we keep going looking at all the provisions that are left in this legislation, we need you to update this charter review to reflect the changes that you now have decided that you wanted to make. So that's really what it comes down to. And
Right.
the debate at the moment is a bit more of a procedural one, where you have on the one hand the Liberals saying, well, we want to just keep going. We'll do that charter review. We want to keep going. The opposition parties, or at least conservatives, saying, well, we want to stop what we're doing until this charter review is completed. The NDP said, we're okay with you stopping as long as you can get all this done within 10 days. So it's kind of the bit of procedural shenanigans a little bit from both sides. But at the end of the day, I think the point that's being made is that there isn't a whole lot of value in reviewing a piece of legislation if it's going to get struck down by the charter, as you suggest, and to go through analysis only to find out later that it is inconsistent with the charter not only wastes everybody's time, but it becomes very difficult to undo some of the work that's been done, which is why you've got many MPs saying, listen, they're asking for a 10-day break. It's basically just a few meetings. Give us that time so that we can be reassured that this new legislation, or the changes you've made to C-10 are consistent with the charter.
And and just so everybody again, and let's just reiterate again that because what I'd like to reiterate again is what is the potential problem for each person out there as somebody generating content on the internet, and what we have said, or what it appears, is that you don't have to worry about becoming a programmer. You have to worry about what your program is. And that is why you say, Michael, and others say, that's where the Section 2B, the freedom of expression concerns arise, correct?
Yeah, no, yeah, that's exactly right. They're not saying we're going to regulate you individually. We're not saying you are a broadcaster like a CTV or a City TV, but we are saying that whatever you post, and let's bear in mind that for so many Canadians, what they post on these sites, this is just basic expression. It's the way they communicate. And suddenly we're saying all of that communication, all that expression is a program subject to certain CRTC rules.
That's right. And that could, again, I use the words trickle down to you as the user. It'll be very, very interesting to see what will happen, Michael. And I always get interested as to who the applicant will be, who will bring the challenge to the legislation. Will it be the platforms, the YouTubes and the Facebooks and the Instagrams? Will they be the applicants who will try to protect all of the people who post on them? Or is it going to take one individual who's going to have to come forward and do this? It will be interesting.
It is interesting. It is worth noting that the platforms didn't really participate in any of this bill discussion, in part because the exceptions were there. They knew their users and all the content from their users was being taken care of. Now suddenly they've in effect had the rug pulled out from under them, where this change was made. It is to me somewhat striking to think that government would move forward with legislation that has this amount of impact and quite literally never have heard from any of the platforms they're seeking to regulate as part of that legislative discussion.
Well, Michael, I really want to thank you for joining me, and obviously not just because of your inherent expertise in this area, but I think it is important for people to understand individually how this potentially affects them. Because when you hear these types of discussions and you hear words like, "Oh, the government wants to regulate what I'm going to say," and that simplifies matters, because I know you'd probably say to me, "Well, that's true, Lauren. That's what they want to do." I would say, well, maybe that's not exactly what it's going to happen, and I think we've established that here. However, you have underscored the importance of this discussion, and the fact that the government is pushing, pulling, and looking at it tells me that they understand as well, or hopefully they do. But I have a very sneaking suspicion, Michael, that this is going to be going to a court one day, no matter how it ends up being drafted at this moment in time.
Oh, I think if it ends up in roughly the same shape as it does now, there's no doubt the length of litigation, the length of the hearings before the CRTC to get this set up is going to take years. And I guess I should note that, the government says there's an urgency here to try to ensure that there's money for the creative sector. this is going to take years before anybody sees a
Oh, yeah.
dime once you create this kind of complex structure that is so open to challenge.
And if I'm the big platforms like Netflix, I'm saying to myself, I like where the discussion is right now. Keep it going. Keep this long discussion going. The longer it goes, maybe the longer it'll take before something like this becomes law.
True, true.
Michael, thank you so much. I appreciate it, and I'd like to have you back on, and we'll talk about this some more. Are you going back to the committee, by the way?
Uh,
Do we have?
the committee's wrapped up, but
Oh, okay. It would have
uh,
been more exciting if you say, "I'm going to run back to the committee now."
all right.
Uh,
Thanks so much for having me.
yeah, take care. Appreciate it. Michael Geist, and again, um, he's earned all his credentials, believe me, and he understands this. And I don't want to keep going back to what I kept going over with him, because I understand the importance of this. There is no doubt that the minute the government wants to regulate something you say, and you say it or publish it in this thing called the internet, there are always those potential problems of your rights being infringed at some point. But you may recall a few weeks ago on Judgment Day, Gary Kaplan and I talked about internet defamation and all the harm that's out there and what people have to do. And indeed, the government, as Michael and I were just talking now, is coming out with a new bill that will just deal with that. The internet is a wonderful place. It's also a dangerous place. And it's a place that you want to be able to just post things and express yourself and not have to worry. But it's also a place where people's lives can get ruined forever because of what goes on there. And so there's all of these balances. And as I said to Michael, there'll be people who would be sitting there thinking, you know what, I don't mind the government coming in here. I'd like this Wild West somehow tamed, but we have to have this balance. Michael used the words due process, very, very important, because nobody wants to be able to just say, hey, that I don't like what's online, take it down, if it's not something that is obviously the type of expression that should be removed. And if you just do that without due process, then now you've gone the opposite way. So it's this unbelievable dance and balance that has to take place. And you can see what's happening with Bill C-10 and just this very specific issue of user-generated content. Does that become a program? And how then, if it is, how will it be looked at as part of the bigger package on a particular platform, whether it's YouTube or Instagram, whatever it is? Not surprisingly, as Michael said, it's going to take quite a while for these issues to be looked at, but these are issues that are really important. It's the internet. Uh, and we are so far from even understanding how to ensure that it's used in a proper way. To me, we're just at the beginning. And the government coming out with a bill like this, while some people want to shake their heads, maybe it is the beginning, and it's the important beginning because it has started a very, very important discussion. All right. That is it for this edition of Judgment Day. Thank you so much for joining me. And of course, I'm not on any of those social media platforms, as I tell you every week, but you can get me. You can email me at lhonickman@btlegal.ca, lhonickman@btlegal.ca. Be happy to take your emails and respond to you. And until the next time, thanks for joining me. Bye, everyone.